Hello again, class. This is another short video on one of our legal research topics for this semester. And this one is going to be spliced back and forth with some websites that I'm going to show you. This is a short video on motions practice. Now, if you ask attorneys, a lot of attorneys, the common thought is that an attorney is good if they are good at oration, if they're a good orator, if they're a good speaker, if they can make a good argument, and that really only applies to trial work. And when I say a good argument, most people think that means fiery, passionate, just all about the thing you're fighting for. And think of me in the classroom, like I'm pretty loud and over the top, and I like to illustrate things, and I'm also an actor and a musician. Lawyers in general are not necessarily that kind of person. Some of us are, a lot of us are, but some of us are not. And what many people in the public don't understand is that an attorney can build a really good practice if they are skilled at motions practice. The fire and the flame and the all of that sort of stuff that we kind of associate with television lawyers can be good at trial, and it can make a jury believe in you and at least listen to you. But motions practice is not about that at all. If you think about it, motions practice can be far more important than those things, because most civil lawyers, if they try 3 to 4 cases a year, that is a rocket docket. The majority of what civil lawyers do is not trying cases in front of judges or juries. In fact, lots of civil lawyers go a year or more without ever going to trial, because much of what they accomplish is done through motions practice. When I say motions practice, I mean the skill and the ability to win portions of your case, or to get accomplished what you want to get accomplished in a case outside of taking it to trial. Remember, a motion asks the court to do something. That's all it is. And there's no, like a complaint, when you learned about writing a complaint, it has to be in numbered paragraphs. It has to be either notice pleading or fact pleading, depending on your jurisdiction. It has to have statement of jurisdiction. It has to be served. It has to have service of process. There's all those things about a complaint. All those things about an answer. Motions practice isn't like that. There's generally a lot more latitude given to motions. I've seen motions that are a sentence. I've seen motions that are long and rambling and 3 pages long, and I'm not quite sure what they're saying. The effectiveness of both of those aside, motions practice can be freeing because you're not bound by all of those different things. Motions practice is helpful for a lot of reasons. It can shortcut issues and claims before going to trial, which is more cost effective for the client. It can keep you out of court, again, cost effective for the client and quicker. It can resolve things outside the presence of a jury. So let's say if you're in criminal court and you know you're going to a jury trial anyway, you can have a suppression motion or a variety of other motions before court, before that jury trial starts, so that you save the jury time, which makes judges happy. So there's a lot of different things that motions practice does, but one of the big things that it's always asking a court to do something. Lots of motions are typical, and we see them pretty frequently. A motion to continue, that means to postpone. A motion to separate witnesses, that means that the witnesses at a trial can't hear what the other witnesses are saying. Pretty common. And then a lot of times in trial work, we have something pop out of the blue that we don't see coming. So we have to ask a court to act on it, but there's not a template for it, so we have to make it up. So motions practice is all of those things in once, and I'm going to show you a couple of examples of a variety of different motions and how we might file them. Okay, so motion type number 1. Here we have our plaintiff. He's the little dude in black right there. And we have our defendant. She's the, yeah, that's her right there. This is in the case of Buster. Come here, Bus. In the case of Buster. 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 In the case of Buster. 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 Can you come here? That's fine. In the case of Buster, the Chihuahua versus Livy. Livy the Beagle. And you can see they're getting along pretty well. Both of them are of the opinion that they need to ask the court for a treat. Livy? Livy, do you want a treat?
Oh. Treat?
Oh, wait. Buster? Do you want a treat? You want a treat? Okay, so see, they're asking the court for something. All right, sit. They're asking the court for something. And our judge today, Oliver, do you want to give them treats?
Mm-hmm.
So you don't care that they have a treat, right?
Yeah, I don't care.
And they both want one. So they're going to write a motion to the court. It says we both want treats, and they obviously both agree. That is going to be what yeah?
They're out of the green ones.
Okay.
So I'm giving them one of the untanned ones.
Okay.
How do you open this, Mom?
Hold on a second. So they're both sitting here, and they're ready for a treat, and they have asked the court in an unopposed motion for treats. And the court also doesn't care they have a treat. They're agreeing on the motion. You can see they both want the same thing. They're both super excited about the same thing.
Ow!
You're fine. They, Livy, the borderline smarter of the two, has written the motion saying that it was unopposed by Buster. It generally speaking,
can you break them apart, Mom?
does not need to be set for a hearing because they both agree and they've had a conference call with the judge. That's what I call a motion with a little m. And so they agree. It's unopposed. That's an easy one. Our next one is not going to be so easy. Okay, so now we have motion type 2, and it is the same as before in large part. Plaintiff, Buster, defendant, Livy, both agree that they want a certain thing, and this thing that they want is more ham. Both of them agree. They file a motion to the court. The only problem is now they have a different judge. And this judge is not okay with them eating the ham because this judge is so upset that he's even running the litigants off because he would like the ham and he is unlikely, to be swayed by their arguments. So most of the time when we have something where the defendant and the plaintiff agree on what should happen, they submit something to the court and the court signs it. But occasionally you're going to get a judge like this judge here, who doesn't care what you want, who wants you to show up in front of him or her in their courtroom and make whatever argument you're going to make. And if you're ever interested in hearing about how I spent my Christmas Eve 2005, it was a situation just like this. And you've got a judge here who is going to make these litigants, even though they agree, show up to argue about the ham. Now, you're not going to necessarily know whether or not that's the case. So you can handle this in one of two ways. You can submit the agreed upon motion and submit it with an order and see what the court says. Some of it is knowing your court and what they want to do on a given case. You'll get a phone call if you think some things should happen and the judge thinks another way. But now we have our substitute judge here. Hi, Judge Pro Tempore. You can go ahead and make your decision on what to do with our litigants and the ham. And if you want to give our judge, who's trying to get more of his own for his own, you can give him some too. So that's uncontested motion type number 2. Sometimes you know when you're getting into it and sometimes you don't.